High wealth districts generate enough revenue to pay for small class sizes, technology in the classrooms, more teachers, art, music, classes needed to be ready for the workforce and for college ready. Districts that can't raise enough money, like William Penn, want these options for their students also. But no matter how much we raise the taxes, the districts cannot pay the bills for pensions, charter schools, special education, and the cost of running a district, and still give the students everything they need to be successful. This is unfair to our students. They are entitled to a thorough and efficient education. I just want you to know, I do believe that some of the most dedicated staff works here in the William Penn School District. They work very hard every day just to provide the basic education for our students. But our students should receive beyond the basic educational services and get what our neighbors in higher wealthy districts are receiving. Education is students' fundamental right. Just want to say, though this decision is a huge step forward, it's just the first step. The legislature does not have to wait for the fair funding lawsuit to be decided. They can pass legislation that increases funding for our schools and distribute it fairly now if they so choose. We implore our legislatures to be proactive and to fully and fairly fund our schools. Thank you.
Good morning. My name is Rowan Hepkins, and I'm the mayor of Yeadon, Pennsylvania, and we're one of the 6 boroughs that comprise the William Penn School District. And I'm here to support our students and the boroughs represented in Eastern Delaware County. And I'm here to say and to reaffirm that the funding formula in the state as currently constructed is very unfair to residents like Yeadonites. We have a very high tax burden, and we're forced to raise taxes, school taxes, year after year after year to make up the deficit and the shortfall that we receive from the state. So I want to hail this landmark decision by the Pennsylvania Supreme Court, and I want to say that thank God there's hope. There's hope for us, there's hope for our students, because someone is listening, and we thank, we celebrate that body to hearing us and giving us hope that we could press this legislation and change the funding formula to one that is more fair to our residents. And I know the governor, and I'm a supporter of the governor, and he has a motto that he wants to create jobs that pay, schools that teach, and the government that works. And with this a landmark decision, we'll be well on our way to have a fair funding formula and to have schools that can really do their job of teaching and having fair amount of revenue to support our well-deserved children. Thank you.
My name is Daniel Eckelsberg. I'm a staff attorney at the Public Interest Law Center, and my office, along with the Education Law Center of Pennsylvania and O'Melveny Myers, brought this lawsuit in 2014. I think my job is to sort of set the stage to give a bit of background on the lawsuit, and those who follow me are going to read from the decision. In 2014, In 2014, 6 families, the Pennsylvania NAACP, the Pennsylvania Association of Rural and Small Schools, and 6 courageous school districts, including this one, got together and said no more. Right? The deprivations that their children had been dealing with for generations, they thought were unconstitutional. They had to be remedied. And so we filed suit on their behalf in the Pennsylvania Commonwealth Court under the state constitution. The Pennsylvania Constitution has a thorough and efficient education clause, and also under the equal protection provisions of the Constitution. That case was dismissed by the Commonwealth Court. And the Commonwealth Court said that this is not the matter for courts to decide. How can a court decide what's an adequate education? How can we get into those sorts of judgment calls? And so we appealed. And last year, the Supreme Court heard argument. This school's marching band was there the day before. There was, in essence, a celebration and a call to action. And about 1 year later, last month, we found out that we won. And there's a couple of things that I think are really important to highlight. What the Supreme Court said was that when you allege the deprivation of such an important right, there has to be a place where you can go to remedy that deprivation. The courthouse doors have to be open for the children of this Commonwealth. The second thing that the court said, and I think is particularly important for this school district, is that calls to local control of education cannot be used as a justification for the deprivations that we see. That ultimately, the state has the responsibility to make sure that every child has the resources they need, which we will prove that they do not. And ultimately, it is the state's responsibility, and the state can't cast off onto the local school districts that responsibility. So now all that's left is to prove the case. Small task ahead. But I'm really pleased to be here. It is not every day that a legal decision gets read by a number of citizens. It's an exciting day to be here, and we look forward to going forward and proving our case.
Good morning, everybody, neighbors, staff, administration, students, advocates. It's amazing to have you here. My name is Rafi Cave. I currently serve as the Vice President of William Penn School Board. I'm an alumni of this beautiful building, a parent in this amazing school district, and I just want to read one excerpt from the ruling. Constitutional promises must be kept. Since Marbury versus Madison, it has been well established that the separation of powers in our tripartite system of government typically depends upon judicial review to check acts or omissions by the other branches in derogation of constitutional requirements. That same separation sometimes demands that courts leave matters exclusively to the political branches. Thank you.
Good morning. My name is Jerry Barber. I live in Aldenboro for the last 15 years. I'm a proud parent of a Penwood High School marching band member, my daughter, who's a junior now, and I'm going to read a portion of the information that you were discussing today. Nonetheless, the idea that any legislator can conclusively determine for the people and for the courts that what it enacts in form of law or what it authorizes an agents to do is consistent with the fundamental law is in opposition to the theory of our institutions. Thus, we must be skeptical of all calls to abstain from a given constitutional dispute. We hold that this is not a case that requires such abstention. Accordingly, we reverse the Commonwealth Court's contrary ruling. Thank you.
I'm a senior at Penwood High School. I serve as senior class president, and I'm also going to read an excerpt from the decision. Petitioners assert that respondents have violated their collective constitutional duty under the educational clause to provide for the maintenance and support of a thorough and efficient system of public education to serve the needs of the Commonwealth. Petitioners aver that respondents have failed to provide the school districts in question with enough funding to ensure that all students have an opportunity to receive an adequate education, where funding is measured by the allocations suggested by the General Assembly Commission costing out study, and adequacy is tested by whether the students are prepared to meet state academic standards and to achieve civic, economic, and social success beyond school.
Good morning. My name is Francisca Makova, and I am former student board representative, and I will also be reading an excerpt from the decision. Petitioners maintain that the current levels and allocation of school funding are irrational, arbitrary, and not reasonably calculated to ensure that all Pennsylvania school children have access to an adequate education. Consequently, petitioners claim the General Assembly has failed to maintain and support a thorough and efficient system of public education. Thank you.
Good morning. My name is Larry Feinberg. I'm in my 18th year as a school board member in Haverford Township, a well-funded district just a few miles from here. And I also serve as co-chairman of the Keystone State Education Coalition, which is a nonpartisan grassroots public education advocacy group. I'll continue reading from the decision. Petitioners assert that respondents have violated equal protection principles under Article 3, Section 32 of the Pennsylvania Constitution. In quotes, education is a fundamental right, triggering strict scrutiny of the disadvantageous classification reflected in the disparity of educational resources at the disposal of low and high wealth districts. Petitioners do not dispute that a constitutional school funding scheme would still enable wealthier districts to provide greater resources to their students than districts that cannot raise as much money through local taxes. But they maintain that the Constitution imposes a duty on the Commonwealth to ensure that all students have the same basic level of educational opportunity. That is, the same fundamental opportunity to meet academic standards and to obtain an adequate education that prepares the student for civil, economic, and social success.
Good morning, my name is Aisha Ortiz and I'm the Vice President of the Senior Class Committee. I'm going to read a part of an excerpt of the decision as well. Respondents argue that this court cannot define thoroughness and efficiency while still respecting the legislature's primacy in fashioning educational policy and preserving its ongoing flexibility to refine that policy to adapt to changing times and evolving needs. But centuries of litigation leading to judicially enforceable definitions of such vague terms as probable cause, due process, equal protection, and cruel and unusual punishment undermine the argument. Courts give meaning routinely to all manner of amorphous constitutional concepts, including those that lie at the intersection of legislative prerogative and judicial review. And they do so while still leaving room for future development by whatever government body or mechanism the law fairly prescribes. Thank you.
Good morning. My name is Desmond Johnson. I'm a sophomore at Delaware High School. I will be reading a portion of the decision. To the extent that our prior cases have been suggested, if mercury that a court cannot provide a judicially discoverable and manageable standard for education clause compliant that does not entail making a policy determination inappropriate for judicial discretion, or that we may only deploy a rubber stamp in the hollow mockery of judicial review. We underscore that we are not bound to follow precedent when it cannot bear scrutiny either on its own terms or
morning. My name is Dawn Hobbs, Aldenboro resident and proud parent of a marching band and soccer parent of 3 children in the elementary, middle school, and high school building. And I have the honor this morning of sharing an excerpt which reads, most explicit, of course, is our dictum in School District of Wilkinsburg versus Wilkinsburg Education Association. Public education in Pennsylvania is a fundamental right. It is required by Article 3, Section 14 of the Pennsylvania Constitution. Before, we rejected the notion that there was an individual right to education. We held that the Constitution's educational mandate does not confer an individual right upon each student to a particular level or quality of education. The simple fact is that none of those past cases conclusively decided the question, and to read any of them to the contrary is to confer upon them more precedential value on that question than they warrant. Furthermore, the mixed signals we may glean from our decisional law echo the conflicting array of rulings in other state courts confronting the same question. We should not treat as settled a question that we have never answered conclusively.
Good morning. My name is Jennifer Ha. I'm a proud parent of 3 Penwood alumni, currently a school board director serving as president. 2 decades after Marbury, in another paean to the importance of judicial review, Chief Justice Marshall cautioned that the judiciary cannot, as a legislator may, avoid a measure because it approaches the confines of the Constitution. We cannot pass it by because it is doubtful. With whatever doubts, with whatever difficulties a case may be attended, we must decide it if it is brought before us. Thank you.
Good morning. My name is Rick Kirkland, president of Park Lane Home and School Association and a proud Darby resident with a child in the 8th grade building. And I'll be reading also. The spirit of Chief Justice Marshall's cautionary refrain has informed the clear majority of state courts that have held it in their judicial duty to construe an interpretation begging state education clauses like ours ensure legislative compliance with their constitutional mandates, no matter the difficulties invited or in many cases confronted. We hold that our education clause, viewed in overreaching context of our case, taking up the question of absenteeism from political questions, compelled to the same result. To the extent our prior cases suggest a contrary result, they must yield.
Hello, I am Miles Richardson. I'm currently a junior here at Penwood High School, and I serve as junior class president. I will be reading an excerpt of the decision. To be sure, courts must take great care in wading deeply into questions of social and economic policy, which we long have recognized as fitting poorly with the judiciary institutionary competencies. However, the judiciary has a correlative and equally important obligation to fulfill its interpretive function. It is a mistake to conflate legislative policy-making pursuant to a constitutional mandate with constitutional interpretation of that mandate and the minimum that it requires. It is fair to neither to the people of the Commonwealth nor to the General Assembly itself to expect that body to police its own fulfillment of its constitutional mandate. Thank you.
Hello, my name is Nathaniel Randall, and I'm a student board representative and secretary of junior class leadership. And I will read an excerpt. We cannot avoid our responsibility to monitor the General Assembly's efforts in service of its mandates to measure those effects against the constitutional imperative, ensuring that the non-constitutional considerations never prevail. over that mandate. It remains for petitioners to substantiate and elucidate the classification at issue and to establish the nature of the right to education, if any, to determine what standard of review the lower court must employ to evaluate their challenge. But petitioners are entitled to the opportunity to do so.
My name is Shirley Howe, and I'm an employee at Public Citizens for Children and Youth. We're an organization associated with the Campaign for Fair Education funding. I want to thank all of you for joining us today to celebrate this game-changing decision. Thanks to Superintendent Harbert, members of her board, the mayor, and others who spoke, who fought, and those who fought before them. Chief among them, Joe Bruni, former superintendent of William Penn School District, that's here with us today. Most importantly, I'd like to thank the many parents who are here, and their students, and the students who read excerpts. It is for you that we do this work, to ensure that you have the tools you need to become successful members of our community and leaders in your chosen fields. The resilience and grace you've continually shown is inspiring to us all. As we move forward in the courts, on the streets, and in the halls of Harrisburg to change the way we fund our schools in this state. Thank you all for being an integral part of this change. Thanks for being here today.